Okay, good afternoon all. So obviously you would have gone through the question papers, everything is done. So you would have, by now you will be knowing the larger importance of polity questions also. So it is around, I think 15 questions are there. So most of the polity questions, like 50%, you can say 50-60% are you can easily solve. So if you have very good hold on the basics. Understood? So if in case some questions they have tried to go a little more in depth, they have talked about is it mentioned in the constitution, all those things as we keep discussing in classes also normally. So please understand that. So I'll try to make it as quick as possible because you've already taken a lot of time. Fine, let's start with the first questions. Question number 51. So look at the question, try to solve first. So consider the following statements. Panchayats at intermediate level exist in all the states. Correct, wrong? Wrong. I'll note everybody. Correct or wrong? Wrong. Why wrong? Huh? Because simple, if you recall 73rd amendment, they keep telling that if the states with less than 20 lakh population will have an option to not have or to have intermediate panchayats. Remember ZP, TP. So for those whom panchayat is not done, don't worry much. Remember the intermediate panchayat. It is an option. If your population is less than so and so, you need not have it. Understood? So exist at all the states, wrong. Second, to be eligible to be a member of panchayat at intermediate level, should attain age of 30 years. It is very, very easy because what is the age? 21 years. MLA Lok Sabha 25. Rajya Sabha MLC 30. President Governor 35. So even if you remember that, answer is done. So that is, you take out that. CM of a state constitutes a commission. First point, look at the word. Chief Minister constitutes a commission to review the financial position of panchayats at intermediate levels and to make recommendations regarding distribution of proceeds of taxes, duties leviable by the state, all those things, playing with the words. In simple terms, this is not for CM. This is for whom? Governor. And this is, you are talking about which one? State Finance Commission, 243I, 243Y. So that concept itself is not there. That means which among those two? Look at the statement. Which of the following are not correct? Means which are not correct? None of them are correct. So answer is all of the above. So panchayat question, a little in depth. That's it. Those, first of all, how many gave prelims yesterday, or at least? Okay. So mostly 2024 or 2025 batch of students. Okay, look at the next question. Again, this is also a little, obviously, a little in-depth question. The question is about the bodies. Not so easy to solve. This one, if you have a broad idea, you would have solved. But still you can try, even if you look at the broader aspect. The power of Lokpal applies to public servants of India. Of course, it applies to the public servants of India, but not to public servants posted outside India. In the simple terms, let's assume whom? Indian Foreign Service officers. Fine, they have specifically added not to the public servants posted outside India. See, always in general understand, Lokpal's purview or jurisdiction will apply to any kind of public servants inside India, outside India. That concept will not apply. Any public servant. Here when you say public servants, you are not talking about civil servants. It's not about bureaucrats only. It also includes whom? It also includes politicians. It also includes right from Prime Minister to anybody. In fact, if you have seen, why did they ask that question, if you just broadly understand. So in some state high court also, even in Supreme Court also, the question was going on that, will the high court judges fall under the definition of the term, what? Public servants. Means, can Lokpal conduct an inquiry against whom? High court judges. That question is still not clear. Supreme Court is looking into it. In one of the judgments, Supreme Court told no, high court judges will not fall under public servants. But final judgment is yet to come out. Maybe considering that, they might have framed this question. We don't know the exact reason, but looks like one or other way it is related to that. So you have to take out that, yes, it applies. Answer is what? It does apply. So this statement is wrong. Chairperson shall not be a member of, chairperson or member shall not be a member of parliament or member of legislature of any state or union territory. Only Chief Justice of India, retired or incumbent, has to be its chairperson. And so see, first statement, you can divide it into two. Take it till here. Chairperson or member shall not be member of parliament or member of state legislature, or that's what, whatever state or union. Even if you use common sense. So first of all, Lokpal's work is what? To look into the corruption cases against public servants. Now, just now as I told, public servants include who all here? Bureaucrats also plus politicians also, means ministers also. Simple logic you apply. If you make an MP or MLA as a Lokpal member or chairperson, why do you think they will go and look into the corruption cases against politicians? Obviously they don't. So even if you apply the commonsensical pattern also, you can easily eliminate first part. Second part is not so easy because they have gone a little in depth. Chief only CJ, whether incumbent or retired, has to be chairperson. The keyword is this. Yes, Chief Justice of India obviously can become chairperson, but the point is, what does it say? Only he has to become is not true, because Chief Justice of India can also become, Supreme Court judge also can become, even retired Chief Justice of the High Court can also become. Understood? So this is the typical, remember the old era of tricks wherein extreme words you can eliminate. Maybe that you could have used, but the point is it's not so easy because all the trick concepts UPSC has already eliminated. By now you would have got an idea. So again, first part of the statement is correct, but second part is wrong. So ultimately it is still wrong. Then chairperson shall not be a member, chairperson or member shall not be less than 45 years. On the date of assuming the office, yes, actually this is correct. Again, this is fact you should have known. It's not so easy. It's a question on body, because remember, if you have gone through all the EPIC classes or polity revision classes, we keep telling bodies are not a very favorite topic for UPSC. 1. 2, even if you look at the PVQ. Second aspect, even if they ask a question on bodies, they'll ask one question. Third point that you have to keep it in mind, look at how many facts are there. So it is not so easy to behead all the facts on all the bodies, because imagine how many number of constitutional bodies, statutory bodies you have. So this one, because only it was in news, you should have known about it broadly. This is not a pattern. You cannot use this pattern and go back and keep revising about all the bodies. Practically, it will not work like that. You should have a broader understanding. That's it. Don't take this as a what? Takeaway. Okay, this next time I'll read all the bodies. This you can take it as a what do you call as this study, because this kind of question every year you will get. Even if you have studied Lakshmikant properly, also you can understand. You can easily attempt this. Clear? Okay, fine. So third statement is actually correct. Lokpal cannot inquire against corruption allegations against sitting PM. Just now I told you. So here public servants includes who all? Bureaucrats also, ministers also. That minister also includes Prime Minister also, Chief Minister also. That means yes, it can inquire against PM also. Of course, some exception is there, that if it is related to decisions related to atomic energy issues, decisions related to whatever space related, so many things, those are all exceptions that you have to take. So that means the only statement which is correct is what? Statement 3. Clear? Okay, fine. So then, where is the polity question? I think it's, one second, question number for polity, 66, 67, 68, 69. Yeah, here only you have. Consider the following statements with regard to pardoning power of President. So please tell the article first. Article 80, President's pardoning power. Article 72. For Governor it is? Plus 89, Article 161. Fine, okay, look at it. Exercise of this power by President can be subjected to, look at the keyword here, limited judicial review. See, first point again, just to revise, in Article 72, remember they would have discussed all those things, commutation, recall all those ones, complete pardon, and then commutation, and then remission, and then respite, and then reprieve, all those things. That you leave it, that is, here they are not asking about it. Broader question what you have to understand is the President decision subjected to judicial review? So obviously in the Constitution there is no clarity about this. Supreme Court in few of the cases has told that yes, judicial review can apply to President's decision also, but not in all the cases. When there is huge delay in taking the decision, mercy petition, if you have kept on pending for a very, very long time. So in only in very rare cases, Supreme Court will look into it. That's why look at the word limited. Understood? If in case UPSC had used the term that it is subjected to judicial review, again it's a confusing statement. Because does it mean limited? Does it mean complete? We don't know. Again it would have become, remember when UPSC released the case a few days back, there was some controversy as to why this answer, why that answer, that it would have become that statement. Because there is the term limited, that means it's safe, it is correct. If you have gone through, I mean, if you recall your polity classes, there are few judgments like Ipuru Sudhakar case, all those things, in which Supreme Court has clearly told that yes, you can subject it to limited judicial review. But when that Supreme Court will decide case by case. In simple terms, it is subjected to limited judicial review. President can exercise this power without advice of Council of Ministers. Even if you recall Article 74, that there shall be Council of Ministers headed by President, headed by Prime Minister, who shall aid and advise the President, who shall act based on such advice. I'm sure even this is also based on advice of Council of Ministers. Even if you want case, Maru Ram case, Supreme Court clearly told that it is based on advice. In simple terms, another aspect is what? It is not a discretionary power of President. It is based on what? Advice of COM. Then again, it's more specific. Which specific ministry? Which specific ministry will give this? Home Ministry. Why Home Ministry? Simple logic apply ಮಾಡಿ, because you are talking about what? Pardoning of the sentences. That means you are talking about whom? Criminals. And crime falls under which ministry? Home Ministry. Understood? So that means without the advice of Council of Ministers is wrong. Answer is clear. Any doubts, please ask. Consider the following statements. Again, playing with the length here. Actual statements, there is no major logic here. Easily you can solve. But they play with English, they play with the length. So that's a mind game. So you should not fall for that mind game. Clear? On the dissolution of House of People, means just to make it simple, Lok Sabha, Speaker shall not vacate his or her office until immediately before first sitting of newly elected Lok Sabha, that is House of People. Yes? No? Yes. If answer is yes, tell me why. Why is this statement there? Because if you recall, the Speaker will not resign even after dissolution. So he will continue till first sitting. Correct. Because one of the reason is what? Because I have told multiple times in classes, if you recall your polity, parliament, all those things, important positions like President or Vice President or PM or CM, all those, including Speaker, cannot remain vacant for a single moment. One or other person should always be there. MP position can remain vacant. MLA can remain vacant, not PM, not CM, not President, not Governor. All those ones, one or other person will always be there. And two, you are talking about, remember, until the first sitting, because in the first sitting, who will come and occupy the position? Speaker pro tem. Recall Speaker pro tem. So Speaker pro tem will preside the first meeting of the newly elected Lok Sabha. Until then, the old Speaker will continue. Clear? So that means on statement is what? Correct. Then look at the second statement. According to the provisions of Constitution, you have to take. Member of House of People, Lok Sabha, on being elected as Speaker, next keyword, shall. Remember in polity we keep telling whenever they use the term shall, what does it mean? Mandatory. So that means if the Lok Sabha MP is elected as Speaker, he shall mandatorily resign from the party immediately. Answer is what? Recall your anti-defection law. There is an exception for the presiding officer, Speaker, that once that person is elected as Speaker, what is the option that he has? He can give up his party membership. Option. Why there is an option, exemption for Speaker? ಏನಕ್ಕೆ exemption ಏನಕ್ಕೆ ನೀವು ಸ್ಪೀಕರ್ ಆದಮೇಲೆ why can you resign? Why do you have an option to resign? To maintain neutrality of the office. Because once you are elected as Speaker, you are not Speaker for your party. You are Speaker for whom? For Lok Sabha as a whole. That's why it is an option. So that means you tell, I am telling option, what is it? What is the word used here? Shall. Shall means what? Mandatory. That means, again just for your comparison, recall UK, House of Speaker, or House of Lords, Speaker position. Once a Speaker, always a Speaker. In UK, what is the provision here? In UK, whoever is elected as the Speaker should mandatorily resign from the party. Mandatory. Not in India. Where? UK. In India, not mandatory, option. Very few people do that. Clear? Third, Speaker may be removed from his or her office by resolution of the House of People passed by a majority of all the then members. That means if you can recall, What majority is it? Effective majority. If you recall, as I keep telling again, though for whom parliament is done, speaker, deputy speaker, Lok Sabha and below state level. Speaker, deputy speaker, Ali Lok Sabha and really obviously which house? State legislature, that is assembly. 2, chairperson, deputy chairperson, Rajya Sabha, state level, council. All of them are removed by effective majority. So that means all the then members of the house exactly constitute from the constitution, they have just copy pasted this statement. Provided no resolution shall be moved unless at least 14 days notice has been given of the intention to move the resolution. Yes, minimum advance 14 days notice. There's also another point, if you can recall, minimum 50 MP should sign in the beginning to start the process. That they have not given. Again, sir, is it based on current affairs? Maybe to an extent you can link, not exactly to the speaker. If you can recall, remember, they initiated a resolution to remove whom? Vice President. Exactly same statement. Even if they give about Vice President also, nothing changes. All the statements, exactly whatever it is, you can take the same answer. Clear? Yeah, so that means, yeah, you tell me the answer. Clear? So second statement, because they have used the term shall, take it as wrong. Then, if any question arises as to whether member of House of People, again Lok Sabha, has become subject to disqualification under 10th schedule, President's decision in accordance with the Council of Ministers shall be final. Who is the decision maker under anti-defection law? Speaker, head of the House. Simple. Then there is no mention of the word political party in the Constitution of India. For your clarity, in the original Constitution, there was no mention about political party. But have they used the term original Constitution here? The reason is 52nd Amendment 1985. That means again, which one? Anti-defection law actually has mentioned the term political party. Because if you can recall, remember splits of the political party, merger of political party, that once you have elected as a member of so and so, you should listen to whatever your political party says. In simple terms, original Constitution not mentioned. But where have they mentioned? 52nd Amendment has mentioned it. So if the statement was, there is no mention of the word political party in the if they add the term what? Original Constitution, statement is what? Right. But in general they are mentioning Constitution, wrong, because it is mentioned now. So that means answer is, got it? In India, state governments have no power. This is not directly polity, but it is actually kind of environment, everything mixed. In India, state governments have no power for making rules for granting concessions in respect of the extraction of minor minerals. So actually, the question is related to Mines and Minerals Regulation and Development, MMDR or MMRD, what they call it as. Even though such minerals are located in there, again, just for you to understand, if you have gone through the PYQs, these questions have kept on coming continuously. It's a kind of very favorite topic of UPSC, MMRD, major minerals, minor minerals. What are major minerals? What are minor minerals? Who has the power to notify what is major, what is minor? Who has the power to make rules? These questions probably even in 21, 22 also they had asked. 1 or 2 years they had not asked, again they have brought it. That time when they had asked in the past, I think they had made it as a kind of factual, more factual, that is, which among the following are minor, which among the following are major, they had asked it like that. This year they have asked about who will make rules, who will notify it, all of them. Simple, what you have to understand is with respect to minor minerals, first of all, what is minor minerals under this act? They don't define. But in general, remember your quarry, what do you call as this, the quarry, sand, clay, these are all normally whichever you find it in your construction, they are your minor minerals. Major minerals are obviously the most important ones, iron ore, manganese, this, that, they all fall under your major minerals. Who will notify? Central government, Government of India will tell what is major, what is minor. Both who will notify? Center will only tell. For major, Government of India will only make the rules also for major minerals. For minor minerals, state government will make the rules. So I have already told the answer, again I am just clarifying. Under MMRD Act, they will tell what is major mineral, what is minor mineral. But definition of what is major, what is minor, they don't tell in the Act. Who will tell what is major, what is minor? These are all major minerals, these are all minor minerals. Who will tell both? Government of India will tell. Who will make the detailed rules about, okay, what is the eligibility criteria to apply for license? How many tons you can acquire? What is the royalty rate? For major minerals, who will tell that? Center. For minor minerals, state. Now you look at it. You look at the statement and tell. State government has no power for making rules for granting concessions in respect of, concession means all these are giving the licenses, this, that and everything. Major, minor minerals, even though they are located in their territories. Wrong, because just now I told they can make rules. 2. Central government has the power to notify minor minerals. Central government will notify both major and minor. But rules who will make? State. That means you look at it. Statement 1 is not correct, but statement 2 is correct. But reason everything, that doesn't apply here. Understood? Because central government notify minor minerals, correct. State government has no power, wrong, it has the power. So 1 is not correct, but 2 is correct. This is not exactly polity, but just to keep it in mind. Then again, simple President chapter, directly you are talking about ordinances. That means first tell me the article. Article 123, President. When can the ordinance be issued? When is an ordinance issued first of all? When both the houses are not in session or one of the houses is not in session. Who can issue ordinances? President can issue ordinance. How can President issue ordinance? Because President has no discretionary power. How will the President issue ordinance? On the advice of Council of Ministers. Understood? And always remember, ordinance is nothing but temporary law. Means whatever a normal act can do, same things who can also do? Ordinance can also do. That means you tell me that means an ordinance can amend any act or not? Yes. Can you repeal an act using ordinance then? I am telling you, just remember one statement. Ordinance is nothing but temporary legislation. Whatever Parliament can do using the normal legislative power, everything President can do using ordinance. That means you can amend any law, you can repeal any law also. You can also make retrospective act. Retrospective means what? Retrospective, prospective. Back end date. So today you pass it, but you tell it will come into force from January 1st, 2025. You can do it. But remember, it is like a temporary legislation. Means ordinance cannot amend the constitution. You cannot amend the constitution. That's the limitation. When you cannot amend the constitution, can you amend fundamental right? Because if you want to amend fundamental right, that means which part of the constitution you have to amend? Fundamental rights. Part 3. If you want to amend part 3, what you have to amend? Constitution. That means which article? Article 368. Now you look at the answer statements. Ordinance can amend any central act. It is like any other act. That means what it can do? Yes, it can amend any central act. Ordinance can abridge. Abridge means what? Amend fundamental rights. Just now I told. You cannot, because what you cannot do using ordinance? You cannot amend constitution. That means what you cannot do then? You cannot amend fundamental rights. 3. Ordinance can come into effect from back date. Answer is what then? Answer is wrong. This is not C. You have to take out this. I think it's a factual mistake. Answer is what then? 1 and 3. You cannot amend constitution. You cannot amend fundamental rights. Not allowed. Using which one? Using ordinance you cannot. Clear? So answer is actually 1 and 3 then. Okay. So consider the following statements. Arunachal Pradesh, again factual statement. The capital is named after a fort. What is the capital of Arunachal Pradesh? Itanagar. Yes, it is. Again, kind of history, kind of geography, all mixed this is. Yes, it is named after Itanagar. Actually, even in your explanation, I think they have given. Ita means what? Brick, Itige. So Itanagar. Yeah, actually, that is a name. So because it's a brick fort, is what they have told. Yes, state has 2 national parks. Again, if you remember, again, kind of environment, geography, all those things. So Namdapa, Mauling, if you know that, you could have easily attempted it. State came into existence, which was Nagaland, on the basis of a constitutional amendment act. Yes, Actually, yeah, this one is a bit confusing. We have to see. Again, just to give you a broader understanding, 1963, Nagaland became a state. Understood? That means it was created as a state by dividing from whom? Assam. Remember, we keep telling entire northeast was only Assam. Out of Assam, they created north. Actually, it is based on Article 3. So when you say it is Article 3, what is it not then? Recall your Article 4. The acts passed under Article 2 and Article 3 should not be considered as amendments to the Constitution under 368. So actually it is not a constitutional amendment act. But if you again recall, Nagaland is given a special status under 371A. So to add, if you want to add 371A, what do you have to do? You have to, like for example, 371J for whom? Hyderabad, Karnataka. So for that to be added, what they have done? 98th constitutional amendment. So actually 371A is added by a constitutional amendment. But Nagaland is not created by constitutional amendment. But what they have told, state came into existence on the basis of Constitutional Amendment Act. So that means with clarity UPSC has not given the statement. But broadly you have to take it as correct now. We still don't know, they may still take it as wrong. Because they are telling state came into existence. Actually both were passed. 371A was also passed and they made a Nagaland, State of Nagaland Act also they passed. So which statement will they take? We don't know. As of now we are taking it as yes because 371A was added same year. Clear? I think 13th amendment or something. Then Tripura, that means this also you have to take it as correct. Tripura initially part C. Recall what do you mean by part C here? In the original constitution the territories were divided into 4. Part A, B, C, D. What is part A? Former British provinces. Like what all? Former British provinces andre yavdu? Like your Madras, like your Bombay, like your Bengal. Then B, princely states with legislature, means bigger ones. Like which one? Like Mysore, like Travancore, like Hyderabad, like Jammu Kashmir. What is part C then? Chief Commissioners provinces plus other princely states. Actually, yes, Tripura was under part C, other princely states. Understood? Because what are the Chief Commissioner provinces if you recall? Delhi, Ajmer, Coorg, Baluchistan 1950 it was not there because Baluchistan became part of Pakistan. It was not there in 1950. Yes, when we were making the constitution it was there. But after partition how will you have Baluchistan? Understood? So those were there. And part D consisted of only Andaman Nicobar Islands. So whatever, you try to go look at your original, I mean in your Union and Territories chapter, part 1, article 1 to article 4, you would have mentioned it. Initially part C state, it became a centrally administered territory in 1956. Recall which committee? Which commission? Fazal Ali Commission, First States Reorganization Commission, yes. And later attained the status of full-fledged state, 1972, reorganization of Northeast. Meghalaya, Tripura, Manipur made separate states in 1972. Same year, Arunachal Pradesh, Mizoram, they made as Union Territory. 1987, they made Arunachal Pradesh and Mizoram as what? States. Understood? So actually, all of them are correct. Clear? Statement 2, I am still not sure. Probably this is correct because of this angle. Clear? Again, this is not so easy to attempt because the reason is they have linked geography, this, that, everything, not geography exactly, environment, everything they have linked. This is very, very easy. Directly you can attempt. You tell me the answer directly. Because the question is what? In simple, they are asking which among the following are constitutional bodies? Interstate Council, which article? Article 263. Understood? Yeah, correct. Then National Security Council. It is not a constitutional body. It was established just as an executive body. National Security Advisor Ajit Doval is heading that. Zonal Council is what kind of body? Yeah, what is Zonal Council? Statutory body. Which act? States Reorganization Act 1956. So that means, understood? So answer is, that's it. Very, very simple. This is no application also. Then Constitution explicitly mentions. Explicit, implicit. What is explicit? What is implicit? Explicit means what? you will find the term in the constitution, that is explicit. Implicit means what? You will not find it, but constitution supports it. Constitution explicitly mentions that in certain spheres the governor acts in his or her own discretion. In simple, because remember, Tamil Nadu governor's continuously issue was there, it is referring to article 163. If you have forgotten article 163, what does it say? There shall be council of ministers headed by chief minister, who shall aid and advise governor, and should, and governor should act based on such advice. Next statement, is last phrase is what? Except where governor is required to act in his or her own discretion. That means, I am telling you the article itself. Constitution explicitly mentions. Answer is what? Yes, it does mention. Which article? 163. That governor, I am telling the statement again, except where governor is required to act in his or her own discretion, it is mentioned. President can, look at the term, president can of his or her own reserve a bill by a state legislature without it being forwarded by the governor of the state. Again, recall Tamil Nadu issues was going on. First governor has to reserve, then only you will get it. President will not have this power. Article 200, 201, recall that. Under article 200, governor has four, what are the options for governor? Same. Give assent, withhold assent, send it back, reserve it to president. 200. 201 says, what are the options available for president if the state bill is reserved to him by the governor? In simple terms, president don't have this discretion. Always remember that core point. Constitution does not provide any discretion for president. President only has situational discretion. But what does governor have? Governor will have both constitutional plus situational discretion. Even if you remember those broader statements also, you can correct it. Wrong, that means answer is. Why is in news? As I told, Tamil Nadu continuously Supreme Court judgment was there. I think this is again very easy, simple. You tell me the articles. Separation of judiciary from executive. Where is it mentioned? Article 50 DPSP. Preservation of the rich heritage of our composite culture. Fundamental duties. 51 capital A. Prohibition of employment of children under 14 years. Which article? Article 24. Fundamental rights. Very easy. Polity only will save you finally. Because if you look at those questions, other environment, geography, this, that, not so easy. Because very technical, whatever they want, they'll ask. At least here they have to ask from the constitution. They have to ask, there is no other option for them. Though they have tried to make it a little tricky, not very tricky. If an area, again if you recall your 5th schedule, if an area in a state is declared as scheduled area, 5th schedule, state government loses its executive power and local body assumes total administration. If you recall in 5th schedule, there is a statement which we keep telling that even if an area is declared as scheduled area, the executive power of the state governments extends even to those areas. What do you mean by executive power of the state governments extends even to those areas? In simple terms, even if an area is considered as scheduled area, state government departments and ministries can easily function there. Means your police department can enter there. So education department can go open schools, colleges there. Your health department can go open hospitals there. Or whatever, social welfare department can go take care of minority, scheduled tribes there. That means a state government loses its executive power is what? It does not lose, it continues. You understood what do you mean by loses the executive power? It will not lose, state government will still have the control. To union government can take over the total administration under on the whatever they are referring to statements similar to which one? Remember article 356 president's rule that the state government of India can take over the entire administration if the state government is not functioning according to the provisions of constitution. That kind of statement you don't have it here. It's not mentioned. A little in depth, even if you had understood schedule 5 in overall schedule 5 and 6th schedule provisions. Remember in your Lakshmikant, you will get it. That also if you had studied also, you could have taken it. Direct statement only. But these are all not very favorite areas for UPS. I mean regularly they do ask, but they ask about which among the following are 5th schedule areas, they ask like that. This time they went into what? statement, I mean, what do you call this? Legal provisions they started to ask. This is very easy again. Your amendment of constitution chapter, direct question. And so constitution under 368 can be amended by two broad ways. One is by special majority, second one special majority plus ratification of 50% of states. Now this is about, look at it, ratification of 50% of states. You recall which provisions can you amend by ratification of 50% of states? In simple terms, federal provisions. Why federal provisions? Which federal means what? If the provision is related to the powers of the state government, then you go take the permission of the state governments is the logic. Understood? Now if you recall your Lakshmikant also broadly, what all provisions will fall under that? Election of the president, power or broader provisions of Supreme Court and High Court, 7th schedule, the executive power of the government of executive power of central and state, legislative power of central and state, Article 368 itself, representation of the states in the parliament, and which one? GST council. I have already told you the answer, you look at it. First one they are telling, list 1, union list, which means which falls under which schedule? 7th schedule, correct. Extent of the executive power of the state. Yes, executive power of center, state, legislative power of center, state. Did I tell anything related to governor here? President's election is there, not the conditions of governor's office. Answer is what then? That's it. Okay, they have not mentioned the answer, it's fine. Whatever, I think you understood that. With reference to Indian polity, consider the governor is not answerable. I think this one directly we keep telling, not answerable to any court. With reference to, yes, always remember, this is you are referring to article number. Remember, we keep dividing into two. Both president and governor will have two types of protection, immunity. One is which one? Professional immunity, that is work-wise. Second one is personal immunity. President and governor both will have 100% professional immunity. What do you mean by 100% professional? You cannot question them for whatever they have done. Impossible. Remember, this is brought from UK. King can do no wrong. That one. Personal, you have to divide into two. Criminal immunity, civil immunity. Criminal immunity, 100%. Remember in your polity classes, fundamental rights, article 14 exemption, I keep telling this. West Bengal Governor Anand Bose, he is given an exemption because last year there was a sexual harassment charge against him. No criminal case. Because when you are in office, 100% criminal protection. But civil immunity, how many months earlier notice? 2 months earlier notice. Look at this. Governor is not answerable to any court in the performance of the duties on powers and duties of his office. Just now I told, that's what is 100% protection. No criminal proceedings during the term of office. Yes. Third statement, they did not ask about civil immunity, they are asking about privileges of MLAs and MPs. Member of state legislature not liable to any court or proceeding. Article 105, Article 194. Yes, in simple terms, whatever they tell on the floor of the house, nobody can question it. Understood? This is what is your recall. P.V. Narasimha Rao case being reversed by Supreme Court. Last year we keep telling that. There was a landmark judgment by Supreme Court last year. That is a mains topic that we will discuss under your mains aspect. They are not liable to any proceedings in any court in respect of anything said within the house. Yes, anything said, it is not there. That means answer is, yeah, all of the above, correct. Okay, this is the environment one. Fine. So how many of you guys have already, which batches you belong to, because I don't know. You guys have to continue, or I mean continue means continue for your mains preparation now or coming back, just for you to understand, because depending on different batches, for whom basic classes are still going on, you complete that. For those, let's say for example, sir, December only our classes are completed, optional are completed. So please don't keep waiting for next year till for your mains preparation, because then you have to start again. Whatever it is, start mains preparation as soon as possible. If you want to revise basics, finish off those basics. Sir, still have environment pending, still have polity pending, environment, economy pending, you finish that. But if that is already done, if optional is done, so focus on mains related GS notes making, because you will not get time later. By January again what you will do? Again prelims. So 4 or 5 months at least prelims. Then next time Then when you come back, then you will start thinking about what should I do for mains. So if in case your basics is done from now till December, it's the mains time. If in case your basics are pending, finish that, then focus on mains notes. Clear? Yeah, okay. So please contact your mentors, they will guide you respectively. Thank you. So mostly lunch break anta. Okay, so now take a lunch break for half an hour. So come back by maybe just half an hour anta helidara. Okay, come back by 3:15. So Ashish sir will continue with environment questions. Please don't miss. At least you will get a broader idea.